Greetings, everyone. Today is our first class on evidence. The evidence questions on the bar are testing in ways which are kind of subtle, in a way that you don't recognize the problem at first unless you have practiced. If you practice, you've seen things similar enough, so you do recognize.
Sorry, did you turn the mic on?
Yeah, my mic is on and the green light is on there, indicating that my mic is on.
Okay.
And it is. Testing, testing, testing. 1, 2. Testing. Okay.
I think you're probably fine.
1, 2, 3, 4.
Go ahead.
Okay. I'll start over. Today is our first class on evidence. If you look at the evidence question that was on the February 2007 bar exam, you learn that the questions are testing your knowledge in rather subtle ways that you may not even recognize what the issue is at first unless you practice. If you practice, you see it. If you haven't, you don't. So writing essay questions, and it's true in the other areas. They're getting better and better in those areas too. So if you practice, it makes a lot of difference, more than in the past. In those situations where the issue which is being tested kind of stands out at you like a sore thumb, then all you have to do is to know a lot of rules, and you see the problem and you can begin to answer it. But in those questions where you don't see the opportunity to use a particular exception to the hearsay rule or some particular aspect of evidence law, in those cases where you don't see it at first, practice makes a lot of difference. And the current questions are coming down in such a way that that prior exposure and practice really matters. So please, for all of your preparation for the bar, actually writing essays is a big deal, not just something you kind of ought to do. It can easily stand in the difference, make the difference of passing or not. Evidence is the body of law dealing with how you reconstruct in front of the jury what happened in the real world. When you attempt to reconstruct in front of the jury what happened in the real world, you use words, that is testimony from people, eyewitnesses. You use documents if they are available, and you use objects like the ball tires and so forth. In presenting these, the testimony of a person or objects or documents, the basic rule is that you look first at what you are trying to prove, and then any evidence which has a tendency to prove whatever you're trying to prove, that evidence is said to be relevant. Any evidence which tends to prove or disprove a fact of consequence, that evidence is said to be relevant if it tends to prove or disprove a fact of consequence. That's at FRE 401. We're going to look at the code here in just a few minutes. But the basic structure is, determine which facts you want to establish. Those are the facts of consequence. You choose the facts that you want to establish by determining that if the jury believes your fact, the facts that you want to establish is true, that if the jury believes those facts, the jury will more likely find that the element that you're trying to prove has been satisfied. Then for the next element, you prove facts such that if the jury believes those facts, they will believe the element has been satisfied. For the next element, you prove the facts of consequence. The way you prove the facts of consequence is you bring on evidence of those facts. And any evidence which is relevant in the sense that it tends to make a person more likely to believe the fact is true or less likely. Evidence which is relevant in the sense that it tends to prove a fact of consequence. All the basic rule of evidence is that all relevant evidence is admissible. All relevant evidence is admissible unless it's excluded by some rule of evidence or rule of law. So once again, the basic structure of the law of evidence is that all relevant evidence is that relevant evidence is evidence which tends to prove a fact of consequence. A fact is a fact of consequence if believing that fact would make it more likely that a jury would believe that an element has been satisfied. The basic law of evidence is that all relevant evidence is admissible unless it's excluded by some other rule. Now, let me put this on the board in such a way that it may be clearer, because it is so important that you understand this basic structure that particularly on performance exams. If you don't understand this basic structure, it's very hard to pass a performance exam. Let's go through this one more time. So let's suppose that you want to prove that there has been a burglary. You're the prosecuting attorney, and there's been a burglary. And at the scene of the burglary, there is a broken window pane, and the glass from that broken window pane is on the floor inside the house. There's a hammer on the floor near the broken glass, and the window is partly raised up, large enough for a person to crawl through. And there's footprints in the flower pot, in the flower dirt just outside the window. Now, you want to convince the jury, you're the prosecution, and you need to convince them that a burglary has occurred. For a burglary, is the breaking breaking and entry, nighttime, and so forth. And so this is your first element. Element number 1, this is element number 2, this is element number 3, and so forth. So you want to prove that, you want to convince the jury there has been a breaking. How do you convince the jury that? Well, there are certain facts that you'd like for them to believe. You'd like for them to believe fact 1. Fact 1 is that a window pane was broken. A broken window, broken glass. I just call it glass. Okay. Fact 2, that the glass is on the floor. There's a broken window pane is what I'm trying to see here. Broken window, P-A-N-E, isn't it? Broken window pane. Secondly, that there is glass on the floor. Third fact you may want to establish that there is that the window has been raised. I'll just take the hammer. Thanks. Now, these are facts such that if you can get a jury to believe that these facts are true, they're more likely to believe that there was a breaking. How do you establish that these facts are true? And the answer is that to establish that this is a true fact, you're going to present evidence. Evidence that there's a broken pane. What's the first piece of evidence you might offer? Well, Let's suppose someone saw the broken pane, and so they're prepared to testify, I saw it. So now you have a witness, so this is going to be testimony. Secondly, let's suppose that besides someone having seen it, you're going to offer a photograph of the broken window pane. So your second piece of evidence is a photograph. The third piece of evidence, maybe you'll bring in some of the, bring in the glass itself. Piece of glass. Now this is the evidence which you like to present to the jury, that this fact is true, and this is a fact of consequence. This is a fact of consequence because believing this fact, this is a fact of consequence because if you believe that fact, you are more likely to believe that this element has been satisfied. We establish this fact by this evidence. How do you get this evidence brought before the jury? Well, the way you get this evidence brought before the jury, if you're going to bring in all evidence that is going to be brought before the jury, there's three requirements. One is it must be relevant. Two, it must have a proper foundation. And three, no exclusions. So let's take the first of these, evidence. Is this testimony that the person is going to offer relevant? Well, if the person is going to say, I saw the broken glass, that testimony is relevant. It's relevant because that testimony tends to prove a fact of consequence. So the person is going to testify, I saw the broken glass. For the photo, how do you get the photograph in? You say, well, same thing. Photograph must be relevant, on proper foundation, and no exceptions. Pardon me, no exclusions. In the case of the photo, you bring the photo to court. Is the photograph relevant? Well, yes, because you can establish that this is the photograph of the very window pane that you claim the burglar came in. If it's just a photograph of a window, a broken window that you found someplace in the world, then it's not relevant. But if it's a photograph of the particular window that you claim was used in the burglary, it's relevant because that photograph tends to show that there was a broken window pane, which is a fact of consequence, and no exclusions. Likewise, if you're going to bring in the glass itself, bring in a piece of glass, it needs to be relevant, a proper foundation, and no exclusions. Once again, if you bring in some glass and show it to the jury, just bringing in pieces of glass and showing it to the jury does not tend to prove a fact of consequence. But if you bring in the glass that was on the floor below that window, and you can establish that that's where that glass came from, then that's what the foundation is about. Establishing that the piece of glass that you have in your hand here at trial is the piece of glass that was on the floor below the window. So it's relevant if it has a proper foundation and no exclusions. And this is how you would bring in the evidence to establish this fact of consequence. Obviously, there are other facts of consequence. Now, this is the law of evidence. That is to say, if you want to get some evidence admitted, how do you do that? Answer, these three things. This is what you always do to get evidence admitted. It's relevant if it tends to prove a fact of consequence. Proper foundation, meaning that the evidence which you are presenting really is connected to the real events. That is to say, this glass that we're going to show you is connected to the real event. The photograph is connected. The testimony must be connected. Well, how do you make sure that the testimony, let's go to the photo first. How do you make sure that the photograph that is, let's go to the glass first. How do you make sure that the glass that you're showing the jury is the glass that was on the floor at that house? And the answer is that's proper foundation. And the answer is that we say we authenticate the glass. That's the word we use for that concept. We authenticate the glass. And when you authenticate the glass, you mean that you give the jury credible evidence that this piece of glass is what you say it is. It's the glass that came from that floor. You could do that by having, for example, someone who was at the scene say that I picked up this glass from the scene, I put it in a police evidence envelope, I sealed the envelope, I put my badge number on it, I took it to the police evidence room, and that's kept locked up, and I went back there this morning just before today's trial, and I got that same same envelope, and I brought it to court and opened it, and here it is. Now that is enough evidence so that a rational juror could believe that this glass is what you say it is. How do you convince the jury that the photograph is what you say it is? That this is not just a photograph of a broken window, but it is the photograph of the broken window that you're trying to establish. And so a photograph of the broken window. How do you establish that? Well, the person who took the photograph, for example, might come along and say, I took the photograph with my camera at this scene. I took it home. I developed it. I put it away someplace. And on the day of trial, I brought it, and here it is. This is the photograph of that scene. Or you might authenticate the photograph in a different way. Maybe the photograph of the window has some feature of the house that is unique, so that if you see that unique feature in this photograph, you know that this is a picture of that house, of this window in that house. And so if someone came forward and said, gee, I know this house very well, I live there, or whatever, I know it very well, and that particular spot on the wall there that has this kind of damage on it, or whatever it is, and a couple of other things about the photograph, that these are all things that are around that window. That's why I know that this is a photograph of that particular window. So you need believable evidence, credible evidence, that the photograph is what you say it is. So that's how you connect, over here, that's how you connect the photograph to the real event, by authenticating it. The way you connect the glass to the real event is by authenticating it. Testimony. How do you connect someone's testimony to the real event? And the answer is that you require that the person who is testifying has personal knowledge of whatever they're testifying about. They were there, they saw it, they heard it, they smelled it, whatever it is that they're testifying about. So they have personal knowledge. Now, if this person was there and they have personal knowledge, and then a few months later they come to trial and tell us about that personal knowledge, all you need is to believe that this person has the ability to remember what they saw 3 months ago, and that they're now telling you what they saw 3 months ago. And so testimony requires personal knowledge, and at common law, the foundation requirement for testimony was not only personal knowledge, but you had to be able to observe, recall, and articulate. Well, observe, recall, and articulate just says that you were there and you have the ability to see it because you got eyes, hear because you can hear things, smell because your smeller works okay. So you had to have the ability to observe it, and now that you're here telling us about it, you have to have the ability to recall it, that is to recall what you saw 3 months ago, and the ability to articulate it to tell us what it is you saw. So at common law, the foundation requirement was not just personal knowledge. It was not just personal knowledge, but it was the ability, personal knowledge, and the ability to observe, recall, and articulate. Now, under the federal rules, the foundation requirement for testimony no longer has all those parts in there about observe, recall, and articulate. Instead, the rule under the federal rules of evidence simply require personal knowledge. And if you've got personal knowledge, the theory under the federal rules is that if you got the personal knowledge and you take the stand, or if you don't have the personal knowledge and you take the stand, that in the course of the examination and cross-examination, the other people at the trial will find out whether you actually know and you're actually able to recall and you're actually able to explain it or not. So you don't need the observe, recall, and articulate. That just comes out in the examination in court. So these are the requirements then that these are the requirements for getting evidence admitted. The evidence must be relevant in the sense that it tends to prove a fact or consequence. The evidence must be sufficiently, that whatever you presented must be connected to the real events, and finally, no exclusions. Now, this foundation requirement is a requirement which does not appear separately in the federal rules anyplace. The common law has used a strategy like this, talking about foundation and materiality and all that sort of thing. The common law has been doing that for years. And so this concept of using the language foundation is kind of rooted in the legal system. But the federal rules of evidence do not mention at all the word foundation anyplace in the federal rules. Because the federal rules take the position that evidence which is not connected enough to the real event is not even relevant. So if I'm testifying about what happened at the accident and I wasn't even there, it's not even relevant. If I'm testifying, if I show you some glass, and if I don't establish that this glass came from that floor that we're talking about, then often the glass is not even relevant. So under the federal rules, the idea was that the concept of foundation gets incorporated into relevance, because without a proper foundation, the evidence simply is not relevant at all. So even though the concept of foundation is incorporated into the concept of evidence, for analysis purposes, it's better to peel it out so you can deal with it specifically, and that's why we have it here, so we can pull it out and talk about it. The federal rules don't say, for example, don't talk about the language foundation requirement, but the federal rules do say that if you're going to offer testimony, you must have personal knowledge. That's FRE 601. You must have personal knowledge if you're going to offer testimony. So the requirement of personal knowledge is in the code. They just don't call it foundation. If you're going to offer the glass, obviously the glass needs to be authenticated or it's just not relevant, and that's how this works. Now, so this is how the system as a whole works. The distinction, in a performance exam, a PT, the bar examiners often ask you, what other facts or consequence do you want to try to establish? And you choose your facts so that if you believe these facts, you'll believe this element has been satisfied. For this next element, there'll be some other fact or consequence. And the next element, there'll be other fact or consequence. And that's how that works. In a closing argument, one of the things that you do is you argue that the evidence which you have presented is credible evidence and sufficient evidence to establish these facts. So you claim that once you get your evidence admitted, in the closing argument at a trial, you argue that the evidence you presented is sufficient, first of all, is credible, that the witnesses were credible, that the photograph was real, and that the glass was the right glass, and so forth. So you say all of your evidence is credible, and not only that, it is sufficient so that the jury ought to believe that these facts are true. And all you have to have is more likely than not that these facts are true. And then you finally need to argue to the jury that if you believe these facts are true, you ought to believe that this element has been satisfied. You make that argument to the jury. If you believe these facts, then you ought to believe that this element has been satisfied. That is how the system works. Now, what we're looking at today, it's important for you to understand this broad system. But what we're working at today is over here, the law of evidence, these three pieces. So for every piece of evidence that we want to get admitted, these are the three requirements for getting that evidence admitted. Now, with that in mind, I want us to take a look at the evidence code because we need some general idea of how the evidence code works, because in the evidence code are all the rules that deal with this evidence. How do you decide if something is relevant? What is the foundation requirement for this kind of evidence? What exclusions? Hearsay, illegally obtained evidence, and so forth. What do you exclude? So we need to look at the federal rules of evidence because the rules for this are found in the federal rules of evidence. So we'll just make a note here that all this stuff is this is all in the federal rules of evidence. And here, all this stuff is in the federal rules of evidence. And here, federal rules of evidence. So we want to look at the federal rules of evidence to see how you determine whether or not evidence is relevant, what foundation is required for this kind of evidence. In other words, how do you establish the connectiveness? If it's a document, we authenticate it, and so forth, and the exclusion, hearsay, etc. So let's look at the federal rules and see how that material is organized. Now, the federal rules of evidence are in your three-ring binder, and if you will open the three-ring binder to the federal rules, you of course see that they are included in there. Well, they're in yours, they're not mine. Now, this particular book just doesn't have them at all. I'll get another book. I'm sure they're in your book. And I'll get another one for myself. So we're going to look at the three-ring binder. Inside this three-ring binder are the federal rules of evidence. Yeah, we keep trying to get Rob to put a green and then put a red cardstock cover where the federal rules begin, but we haven't been able to get him to do that yet. But we'll keep trying. So the federal rules of evidence are at the end of the questions and answers on evidence in your three-ring binder. There is no cardstock separating it, so you have to locate it. It follows page 152 is where page 153 would be if you had such a page. Now, if you look at the Federal Rules of Evidence, let's turn to Federal Rules of Evidence are organized into 10 articles. Let's talk about them. Article 1. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And let's talk about the gist of what is contained in each of these articles. Article 1 is the general rule that says, what is the purpose of the law of evidence? And the purpose, of course, is to help determine the truth at a trial and that kind of lofty stuff. And so that background is interesting, but nothing specific you can do with it. Still in Article 1, however, there are two sections in Article 1 which are quite important that you want to take a look at. And those are 104B and 105 and 106. So 104B, 105, and 106. 104B is the section that deals with conditional admissibility, conditional relevance as it's called, and in particular it's called relevance conditioned on a fact. And so at 104B there's a rule that says if the evidence that you're offering, you claim it's relevant, but in order for it to be relevant, you need to establish some other fact as a true fact. And once that fact is established, then it's clear that the evidence is relevant. For example, a truck driver has an accident, and the truck driver makes an admission, says, I ran the light. Well, if the truck driver was driving your truck and says, I ran the light, you're the employer, and this truck driver was driving your truck, your employee, and says, I ran the light, well, that's an admission that's against you. But if you claim that you are not the owner of the truck, that the truck driver was an independent trucker, and they have their own business, and they were just hauling something for you, you're not the employer, then the admission by the truck driver that I ran the light, really, if you are the defendant in the lawsuit, the fact that this stranger admitted that he or she ran the light really is not relevant in the suit against you because the person's not your employee. So whether or not this person who made the admission is or is not an employee of yours is important, and you can't determine whether or not that admission is relevant until you know whether or not the person is an employee. So that's an example where the relevance of some evidence depends on whether or not some other fact has been established. Now what 104B says is that when you have that sort of situation, it's okay for the court to admit this evidence conditionally. It's admitted on the condition that you establish this fact later on, and if you do establish the fact, evidence comes in as relevant. If you don't establish the fact, the judge will ask the jury to ignore that evidence. So 104B is about conditional relevance. It comes up on the bar from time to time. It came up in exactly the situation I just told you about the truck driver. The next one, section in Article 1 that you need to take note of is 105. 105 is important because it is tested on every evidence question on the bar. Okay? There has never been an evidence question on the bar that did not test 105. So it sounds like something you want to know. 105 is the rule regarding limited admissibility. Evidence for limited admissibility, and there are lots of situations where the evidence is admissible for one purpose, but it's not admissible for some other purpose that you might use it for. For example, a person might make a person might be asked to speak before the jury, so the jury can hear the person's voice for some reason having to do with the trial. And so if the person speaks so the jury can hear the voice, the message that the person says, the person might say, yes, I did it. The person might be asked to say these very words. Yes, I did it, and after I did it, I stuffed the body down the garbage disposal and turned it on, and that's the last I saw of the body. Kind of gruesome, but the point I'm getting at is that if the person is asked to speak those words in order for the jury to hear the person's voice, then that evidence is admissible for the voice, for the sound of the voice, but not admissible for what it says, the contents of what it says. And there are lots of other situations where evidence may be hearsay and not admissible for truth, but is admissible for some other purpose. So we get lots of that sort of thing. Every bar exam has something on it where the evidence is admissible for one purpose but not another. A person who was is accused of committing a crime, and if you have evidence that this person has committed very similar crimes in the past, maybe lots of them, and you're using the evidence of having committed crimes just like this as a device to identify the person, because the modus operandi was unique enough so that any person who commits a crime with this unique MO is probably the same person. And so you want to tell the jury that one of the ways that we are identifying this defendant is by the modus operandi that the person continued to use. Well, although the MO may be used to identify the person who committed the crime, the jury might still be told that you may not use the prior crimes to show that this person has a propensity to commit crimes and therefore it's more likely they committed this crime. You can't use it that way. You can only use it to identify. And for example, there have been 5 bank robberies, and we caught the person who robbed the last bank and caught him in the act. But each of these 6 bank robberies was done in some very unique way, including the one when the person was arrested. Well, if the method of committing the bank robbery was unique enough, couldn't you make the argument that the person who committed bank robbery number 5 that we caught also probably committed 4 because it was the same MO? So you can use the MO to identify the person who committed bank robbery number 4, but you cannot use the previous bank robberies as evidence that the person has a propensity to rob banks and therefore more likely rob this bank. That's, again, limited admissibility. And that kind of use of 105, something of that sort, is on every exam, every evidence exam that's ever been on the bar. So keep that in mind. Finally comes 106. 106 is not tested quite that broadly. 106 is the doctrine which says that the completeness doctrine says if the other side is offering material out of a book or a paragraph out of a document or a sentence out of something, that you can require that enough of that document, a book, a pamphlet, a paragraph, or whatever it is, enough additional material is admitted so that what was admitted is not misleading because it's been taken out of context. And things taken out of context obviously can be misleading. And so your 106 says that when that happens, you can get the rest of the context, enough of the rest of the context admitted so that the evidence is not misleading. So that's the stuff we need to keep in mind with Article 1. 104B and the other ones. Next, Article 2. Article 2. Article 2 is about judicial notice. Now, judicial notice is simply the judge saying to the jury that this court is telling you that here is a true fact, even though we haven't presented separate evidence on this fact. And you must, in a civil case, conclude that this fact is true. For example, there's a trial going on, say, in the city of San Francisco. And in the city of San Francisco, First and Market Street is a part of downtown San Francisco. Well, people who live in San Francisco know that. And the court doesn't need to take separate evidence that First and Market Street is a part of downtown. The court can just tell the jury, look, First and Market Street is a part of downtown San Francisco. You're stuck with that piece of information, period. Conclusive. It's true. You must conclude that's true. Well, the court, the way we say that in formal language is we say the court takes judicial notice that First and Market Street is a part of downtown San Francisco. And when the court takes judicial notice, then the jury is bound by that fact. I'd like for you to read the judicial notice section, section 201, and I'm going to stop for a minute and ask you to actually read 201. The reason I want you to read this stuff is because most of the time when people go through law school, they never read the federal rules of evidence. They just listen to other people talk about it, and they read outlines and stuff like that, and they even read cases. But the actual rules themselves, they don't sit down and read them. And if you look at the bar questions, you can see it is very clear that the language in the code is what the bar examiners are looking for. So I want you to get used to reading this stuff. Please read 201 right now. We're going to stop for 3 minutes while you do so. I'm going to turn off the mic for 3 minutes for you to read that. One more minute, and then we will continue. 30 seconds. Okay, I hope you had a chance and did read Article 201, providing judicial notice. And you notice that what it says is that if you want the court to take judicial notice, you can do it two ways. You can ask them to take judicial notice of a fact which is well known in the geographical territory area. First and Market Street is a part of downtown San Francisco. You can ask the court, please take judicial notice of this fact, and the court will probably tell the jury that. On the other hand, if you want to tell the judge, please tell the jury that May the 1st, 1937 was a Thursday. And now that's a fact that is not really subject to dispute, because you can determine that very easily. No two lawyers are going to go to court and seriously argue the question of whether or not May the 1st, 1935, whatever I said, was a Thursday. You would instead bring an almanac or something of that sort that's reliable and show the court that it's a Thursday. And so that's another type of evidence for which the court can take judicial notice. That is, facts which can be established by reference to a source that is not really subject to dispute. So that an almanac or something of that sort, not really subject to dispute, and you say, see, Judge, right here, that date is a Thursday. And now the judge can say to the jury, ladies and gentlemen of the jury, whatever day I said, May 1st, 1935, is a Thursday, and you are stuck with that fact conclusively. So two kinds of things that the court can take judicial notice of. One of them is judicial notice of fact which is well known in the territory, and you saw that here in the reading. And secondly, facts where I can establish them in such a way that reasonable people will not even argue about them. In that case, I have to present that evidence, I have to present the almanac to the jury, to the judge, or whatever it is I'm going to present to get the court to take judicial notice. I have to present that, and then the court can take judicial notice. And finally, please notice that the court can take judicial notice of fact on its own. It can take judicial notice of, it can decide for itself it wants to take judicial notice about something. Now, the 201G is the point that is often tested, judicial notice. Take a look in particular at 201G. And 201G makes a different distinction between the effect of judicial notice at a civil trial versus a criminal trial. So that's what Article 2 is about. Article 3. Please turn to Article 3. And Article 3 is about presumptions. Now, I'm going to tell you what Article 3 says about presumptions, and then after I tell you, I want you to read it so you can see that that's what it says. But until I tell you about it, or unless you already know, reading the rule itself in the absence of understanding what it means will take you a long time to figure it out. So we have about 2 minutes before our break. So what we'll do is we'll take a 12-minute break now, and when we come back, we'll pick up here at judicial notice. Let's take 12.